In this first lesson on jurisprudence, what we're going to do is take an introduction to the study of the subject, as well as introduce a number of key ideas. So more specifically, what we're going to do is ask ourselves the question of what is jurisprudence? What does it mean when we're talking about doing jurisprudence, for example? We're then going to have a look at trying to examine what jurisprudence is by looking at the kind of questions that are asked when we are trying to discuss jurisprudence. And then by looking at these questions, we're going to extend our understanding of the subject, our broad understanding of the subject, by having a look at some of the more significant schools of thought within jurisprudence, and we're going to introduce a couple of them in this lesson, which is we're going to introduce natural law theory, and we're also going to introduce legal positivism. These are obviously two bedrock ideas within jurisprudence, and they're going to be two theories that we're going to expand on in later lessons, but it's just important to have a look at them in this lesson just to get a general idea of what they refer to. And then we're going to finally finish off by looking at alternative theories within jurisprudence. So the first question is, what is jurisprudence? And there are really a number of different names that you can attribute to this subject, the study of jurisprudence. We could describe it as classical legal theory. We could describe it as the philosophy of law. We could talk about it being legal philosophy or just legal theory, all these different kinds of things. So really, when we are talking about jurisprudence, or if we refer to it as the philosophy of law, or we refer to it as classical legal theory or legal philosophy, we're basically referring to the same thing. That all these things study very similar different things. So these generally refer to the same kind of topics. And what we call classical legal theory, or what we call jurisprudence, when we refer to that, we're referring to the most classical Western legal theories. Now, when we talk about Western legal theories, there are obviously other legal theories and legal schools of thought that exist in different parts of the world, but generally we're going to keep to a Western narrative just because of the simplicity and ease of being able to understand and study it. In a more advanced set of lessons, I'll probably go into other theories from around the world. And we also refer to it as classical legal theory because most modern legal theories, most modern theories of jurisprudence are either in response to the classical theories or they are somewhat grounded in said theories. So these classical theories that we're going to be talking about, things like natural law, legal positivism, some of the social responses to jurisprudence, these are all grounded theories that the more modern variations have built upon or responded to or critiqued, for example. So really, what does classical legal theory study? What does jurisprudence actually study? What are the kind of questions that we're going to look at? Well, the first thing we're doing is we're taking a theoretical approach to law. We're not going to be talking about and analysing specific legal systems, specific legal regimes. We might refer to some specific legal regimes to bolster some theories with examples, but for the most part we will be taking a philosophical approach, a theoretical approach to these regimes, because ultimately we won't need to be analysing specific areas of the law to understand jurisprudence, because jurisprudence or classical legal theory it almost permeates all law, regardless of the type of law that we're talking about. And of course there is a distinction that ought to be made between jurisprudence, the philosophy of law, and the philosophy of different areas of law. There are two other main ones that tend to get their own kind of study, which is the philosophy of criminal law, which is also a very theoretical one in nature, and also the philosophy of human rights and human rights law. There are a number of different philosophical tools that we're going to be using to examine legal theory, so we're not going to be taking any kind of approach whereby we analyze case law, where we subject ourselves to any kind of exegesis of case law or a textbook. We're looking at more theoretical philosophical tools. These are things like ontological analysis, the study of existence, the metaphysical study of existence, as well as using logic and also the study of knowledge, which is epistemology. And because jurisprudence is very highly theoretical, it's an ever-growing subject, and there are a lot of complex branches which also branch off from each other, and there are lots of things to be talked about. We cannot cover everything in a single set of lessons, so there will be extra things that we could add on to. So let's have a look at what the questions we're going to be asking. What are the kind of questions that somebody who engages with jurisprudence wants to look at? Well, one of the questions is, what is law? If I say this is the law, what am I actually referring to? Is there a way in which we can define the law that encompasses all kinds of different areas of law? Because as we know, the law is very broad. There are different subjects within the law, so you can not only is it does it vary horizontally, you've got different kinds of law like contract, torts, trusts, for example, etc., etc. These vary horizontally. But you've also got some kind of vertical variation, because then you've got things like national law, you've then got EU law or other kind of institutions, and then you've got international law. So there are all these different broad offshoots of what law is, and how can we define law in a way that encompasses all of these theories and all of these branches? What does it mean to call something law? This is obviously an extension of the first question. When I say that this is the law, what do I actually mean when I say that? How do we define it in that way? Why do we have the law? Okay, what is the purpose of the law? Is it to provide justice? Is the law meant to represent societal morality? Is that supposed to be a question that is asked? Does the law represent fairness or equity in some way? How is it that we can juggle all of these different kind of approaches together? What does the law do? Again, this is also tangentially related to the first point. To the previous point. Does the law provide justice? Does the law provide justice for everybody? Can the law even provide justice and equality for everybody? Does the law only provide these things like justice and equity for the greatest number of people? A kind of utilitarian approach. Is that the way in which we can define the law? Is there some areas where the law is impossible to enforce? These are the kinds of things that we ask there. And then we're going to finally talk about what the law should do. This is different to what the law does do. What the law does do is a descriptive question. We're asking what it actually does in the world, if we can use our empirical understanding of what the law does to try and work out the kinds of things it does. But what it should do is a prescriptive question. What ought the law do? Should the law uphold these different virtues that we've discussed, or should the law do something completely different? Should the law be prescribed anything at all? Is there even any kind of obligation onto the law to do anything? That's a question that we could ask. And obviously, with all of these different questions, we have lots of different schools of thought. Now, not every single school of thought even accepts all of the questions or even relevant questions. Some school of thought will reject some of the questions that we've asked in the previous slide. So historically, there are two major schools of thought in jurisprudence, and these are natural law theory and legal positivism. And these form the bedrock of our Western interpretation of jurisprudence. And again, of course, there are other areas of jurisprudence around the world. So let's begin by talking very, very quickly, introducing the concept of natural law. We've got an image here of St. Thomas Aquinas, because Thomas Aquinas developed natural law was one of the key developers of natural law from a broader perspective, not just from a legal perspective. It originated within Greek philosophy, and like I just mentioned, it was developed by Christianity, namely St. Thomas Aquinas, and this is how natural law developed. And natural law effectively asserts that for the law to exist, there has to be certain pre-existing conditions that must be met. So there has to be ways in which we can assert that the law exists. And it is effectively encapsulated in the following axiom. So the following axiom states that an unjust law is not a law. So effectively, there are these fundamental conditions that exist. There are these fundamental conditions that exist that mean without those fundamental conditions being satisfied, a particular law or a particular set of laws or a particular legal regime does not constitute the law. Okay? And so that is why there are these substantive necessary conditions to the existence of the law. That is what we have here. And if we notice within the axiom that we have just described, we're referring to an unjust law not being a law. So we're referring some kind of, and we're extending some kind of morality onto the law, i.e. a law that is not just, okay, it doesn't promote any kind of justice, therefore cannot be the law, which implies that there is a certain set of morality. There's a certain morality behind what makes law law. Natural law thus sets a number of certain standards to determine what the law actually is, and we will look at these standards in a later lesson, specifically the next lesson. And we effectively measure legal systems against natural law conditions to determine whether or not they fit within the conditions that are established. By contrast, legal positivism, which is the other major bedrock theory of jurisprudence, okay, in all its variations, because there are variations that we will discuss, legal positivism rejects the notion that law has any kind of substantive norms for its existence. Okay, so this is fundamentally a challenge to natural law theory. Therefore, an unjust law could still be a law. Okay, it rejects the natural law interpretation that there are these substantive conditions that are required for something to exist within law. And that also implies that there are no moral conditions for the existence of law. Now, when we refer to there being no moral conditions for the existence of law, this doesn't mean that there isn't some kind of connection between law and morality. The concept of legal moralism, okay, that the law should reflect morality, or at least the criminal law should reflect morality, okay. This is not something that is incompatible with legal positivism. There can be a connection between law and morality under a legal positivist framework. The only distinction is that legal positivism doesn't assert that morality is a necessary condition. It has to exist for the law to exist. That is the key distinction. It's quite a nuanced distinction, but it is something that is nonetheless very important. Okay, the law can exist even if it is unjust or immoral. Okay, we can use examples like the most common example is the legal regime under Nazi Germany, for example, whereby between 1933 and 1945 we have a legal regime within Germany that most would argue is very unjust, okay, but it's still nonetheless law according to legal positivists, because there are still, acts that are passed, cases that are deliberated, regulations that are pushed through, upholding of the law, okay, regardless of whether or not these laws are moral or immoral. And a very good example could be the 1935 Nuremberg laws, which in Nazi Germany stated that it would then be illegal for Jewish people to marry non-Jewish people, and etc., etc., etc. It started out this kind of this racial superiority of the Nazi regime. Most people, hopefully most people today, would argue that that was an unjust and immoral piece of legislation. But is it still nonetheless law? Another similar example could be segregation, Jim Crow laws, things that were in the American South, things that laws that segregated black people from white people within society, within on buses and all these different kinds of things as well. Arguably, these were still laws, but they are still nonetheless immoral. And so a legal positivist will assert that these examples show very clearly that you can have laws that are still laws, but are still immoral. Finally, we're going to talk about some alternative theories. So those are the two main bedrock theories. What are the more alternative theories that we can discuss? Well, there are a few ways in which we can discuss jurisprudence from different alternatives. We can talk about alternatives as a way of responding to natural law and legal positivism. So there are a number of people like Dworkin, for example, who responds and critiques things like legal positivism. You could also talk about Durkheim's theory of law, Emil Durkheim. We've also got Max Weber's theory of law, and we've also obviously got Marxism and Marxist legal theory. These three fit under the umbrella of what we would describe as sociological theories of law, so law and society. And when it comes to law and society, we've got these kind of theories here, sociological theories, and then we've also got things like law and justice, how in which those two concepts interrelate between each other. We also have law and politics. To what extent is law just politics, and vice versa? And so therefore we've got a number of different theories that really encapsulates a very rich area of discussion, of philosophy within legal philosophy specifically. So to finish up, what we've done in this lesson is introduce the concept of jurisprudence. We've tried to come to some kind of definition. We've come and had a look at some of the kind of synonyms that exist within jurisprudence, things like classical legal theory, legal philosophy, etc., etc. We've looked at the two main schools of thought within jurisprudence, namely natural law and legal positivism, and then we've introduced some of the a number of different extra alternative